My lord, item number 2, my lord. With the apology, my lord, I beg to state that, my lord, so far as the file is concerned, it has been entrusted to me today, my lord. I think some time to prepare it.
The pending says.
I understand, my lord. The
2020.
landed AG is, my lord, today within court number 1, my lord, relating to an entry tax series, which will start today.
No, we understand, but it's very difficult to construct.
I understand. That's why I take the apology, my lord.
My lord, your lordship,
My lord, I will appear, my lord.
my lord, your lordship in this case wanted us to give a, my lord, a bullet. We have to, I furnish it today, my lord. Your lordship can.
In order to expedite,
But your lordship,
both sides to give us the list of
that
bullet points.
Lordship.
only the bullet points.
And the issue is so small that
Yes, otherwise,
not
my
be
lord,
kept pending
whether
for.
education institution will come under.
And I'm told, my lord, your lordship heard the matter also on earlier occasions.
But bullet points, my lord, I will furnish it, my lord, before the next date fixed. In fact, I will provide it to the court, my lord.
We adjourned this matter for so long. We are expecting it on 28th of July. But if no prayer for adjournment shall be considered, and we'll close the matter even if matter is not being.
I am obliged, my lord. I will, my lord, give the bullet point to you and before that.
Lordship fixed it 28th of July.
Even if no argument is advanced, we'll go ahead with this bullet point and then decide the law. And Mr. P.K. Roy, on senior counsel for the. So you said Mr. P.K. Roy, on senior counsel for the petitioner is present. Mr. B. Google, under additional advocate general, pays for some time to make his submissions. Before that, first paragraph is present, and he has submitted the bullet points of his submissions, which is made a part of the report. Then he pays for time. As it's a old pending matter, the prayer for adjournment is reluctantly allowed. However, on a condition that the state shall submit their bullet points of submissions at least a week in advance of the next date of the state, is made clear that no prayer for adjournment shall be considered on that next date, and the matter shall be closed, and if any prayer for adjournment is made, the matter would be closed and the court would proceed to pronounce the order on the basis of materials available on record. List on 28/7/2026.
Highly objective.
Item 1.
Please allow.
Kindly have a look at order dated 22/11/24. That will summarize the whole issue, Your Lordship, while passing this out. Yes, please. But I have some addition to it, my lord. Yes, yes, 9 and 10. And my lord will also have a look at Rule 29, my lord. 27 of the Assam Cooperative Society election rules. In fact, I was engaged yesterday only, my lord. But it is in the Act, if your lordship would see, that Assam Cooperative Societies Act. Yes. If your lordship having the same, lord, it would be page 120.
My lord can take my book.
Yes.
Any dispute relating to election of a cooperative society may be submitted within 3 days from the date of declaration of the results before the election authority. So, my lord, my additional argument would be, my lord, your lordship sees the term use is may be submitted. So it's not shall. And my lord, there can be circumstances when may can be read as shall. And moreover, my lord, no consequences have been provided that if it is not submitted within that period, what would be the consequences? In that event, my lord, it would be read as directory, not mandatory. But the facts are not disputed, my lord, that it was submitted on 15th. That is also held by learned single judge, my lord. Since it's a question of law, my lord, though it might not have been raised in the writ petition, my lord.
This only 3 days are given.
My lord.
They would have given a vague legislative intent if there was no intent to read shall as may shall.
My lord.
Then why 3 days?
Lord, a time period has been prescribed. Lord, even, Lord, like similar provision, Lord, where in Arbitration Act, Lord, 34, then 120, 90 days plus 30 days, Lord. The consequences there, Lord, you can't be no submitted any further. Even interpreting, Lord, the regarding order rule 8, Lord, order 8 rule 1 regarding CPC, Lord, whether the 90 days is mandatory or directory.
So because it contains some time for extension. That's why it
But
is-
my submission for your lordship's consideration would be, Lord, good. I have limited time, Lord, I could not expound on that aspect. But since consequences is not there, even the Hawks Chemicals case, Lord, 1974, if I correctly remember, Lord, their lordship has decided that there is a guidelines for determining whether it's a mandatory or directory. If the consequences is not provided, my lord, it has to be read as directory.
Which citation you are referring to? Just give the name.
Company was the First Chemicals, HOEST to the chemical,
F
HOE,
or H chemicals.
yes, yes. There the provision was regarding laying down of rules before the assembly or parliament, my lord. And there the consequences were not given, my lord. The apex court had held, since the consequences are not there. In a case where the consequences is given, it has to be read as mandatory. In a case where the consequence has not been given, it has to be read as directory.
The year 83.
83, maybe 83. I think it's 1983 4 SCC 45.
Which paragraph? Because we are not finding it. We are open. We
80
opened that up.
83 4 SCC 45.
So that is available. Which paragraph? In the meantime, we are hearing them.
My
To
lord,
find that
I'll
paragraph
just
which
find it.
happens. Because in this case, the facts were that the bigger manufacturer was imposed higher taxes to him.
My lord,
And then it says it couldn't be passed off. The report justified it.
I'll address on this. So far as fact is concerned, in this case, there is no dispute as regard that, my lord. And my lord, the registrar, my lord, just one aspect in the impugn order, your lordship would see, the registrar has approved it only because that complaint has been withdrawn. But it has come to its notice what is the allegations. But whether, my lord, another argument would be, my lord, whether once it comes to his notice, my lord, whether he can say on the application of any person that there is no dispute, so it's fine. Or, my lord, he has to look into it.
Principle of waiver. If make a complaint and withdraw it,
My lord.
you waive.
But the lordship has recognized the defects, my lord, the alimonies. Based on that, my lord, that submission was made.
Yes.
May I please as a lordship? My lord, the issue which has been raised herein in the instant, my lord, appeal. My lord, admittedly, my lord, they have not raised it before the, my lord, honorable learned single judge, my lord. It has been completely, my lord, skipped, or there is no, my lord, averment also made in the writ petition also, my lord. Now, for the very first time, my lord, they have introduced this in this writ appeal regarding the by taking advantage of the, my lord, by taking recourse of the General Clauses Act, Section 10 and 11, by counting, my lord, Sunday, Saturday and Sunday should be counted, my lord. That is their main ground. Now, my lord, whether this can be done in a writ appeal, my lord, where is this, my lord, they have raised this issue as a question of law, my lord. So therefore, it can be raised, my lord, at the appellate forum also. This is their contention, my lord. But my lord, my respectful submission, my lord, is that, my lord, when something is not there in the writ petition before the learned single judge, my lord. So in an appellate forum, my lord, by taking that plea for, my lord, deciding the issue, my lord, will be, is not, my lord, very proper. My lord, which I have found out a very few judgments regarding that when something is not been pleaded or, my lord, argued, or, my lord, is a part of a record before the learned single judge, then it is very difficult to, my lord, avoid in and writ appeal, my lord. The principle has been laid down in a judgment, my lord, which has been, my lord, recently reflected. It's a very recent judgment, civil appeal number 2950 of 2011, my lord. Uh, uh, Makhwadhas Ram versus Jagdish Rai and so and so, it is a civil matter, my lord, of 2950 of 2011. Prohibition. My lord, I am straight away, I beg to draw my lordship's attention to paragraph 5, my lord. At page 4, my lord. Paragraph 5, my lord. May I read, my lord? Par contra, the respondents contended that there is no requirement of furnishing plain written statement and other documents to plead res judicata when the judgment in the case reflects same and similar cause of action. It is further submitted that if the sale deed of so and so claim of the plaintiff that ought to have been pleaded as the main ground and that the ground of being the exclusive owner of the land in question so and so, my lord can skip this para 5. The relevant part, my lord, all the case laws has been discussed in para 7, 7.1. And my lord, lastly, in paragraph number 8, my lord, page 7 is the, my lord, finding of the judgment. From a considered perusal of the above judgment, the following aspect of the constructive res judicata can be highlighted. 8.1 Constructive res judicata mandates that all grounds that might and ought to have been employed in the proceeding should be employed to avoid multiplicity of proceedings. It is a deeming fiction of law, but its application is to uniform and instead is dependent on the facts and circumstances of a particular case with due regard to ambit of the earlier proceeding and the nexus which the matter bears to the nature of the controversy. The principle is found on public policy. It is a generally acceptable rule that one person should not be vexed twice over for the same kind of litigation. As such, it is also applies to the proceeding under Article 226/32 of the Constitution of India. In respect of ought referred above, the said word implies the threshold to the above mere responsibility. The parties, while conducting litigations, are expected to apply reasonable diligence, legitimate purview. It is from this lens that it shall be adjudicated whether all issues that were properly arising to the litigation, which ought to have been raised, were raised or not. The principle applies with the equal force in case where the ground that might and ought to have been raised was not done on account of negligence,
Just a moment.
inadvertence. Mal.
कौन सा वाला?
This,
My lord,
this order may not be helping you.
my lord,
You see, the reason is, please come to paragraph 1.
my lord. The civil appeal has been prepared, my lord, by
Yes.
the original plaintiff.
Now in paragraph 2, you will find that there is a transaction, and
my lord.
against this transaction, you fourth line or fifth line, you will find that name Ram Bhajan,
My lord,
correct?
correct.
After that, there will be a GP and GPA and all everything. And then on the last 5 lines, you will find that the second transfer was dismissed by judgment dated 31/7/1975.
My lord, my
So
lord.
that is the first suit. Now, if you come to the second paragraph, then you will find the suit. So and so 87 has been filed for declaration. And again, you will find that name Ram Bhajan. So therefore, the suit was between
Continuation, my lord.
two suits between
My
the
lord,
same
my lord,
parties
my
or
lord.
the parties claiming through others. Therefore, the constructive res judica comes.
My lord, may not come into play, my lord. No, my lord, my lord, my lord, main intention to bring the judgment to before my lordship is that, my lord, the due diligence, which has been said to be, my lord, the parties while conducting litigations, my lord, are expected to apply the reasonable diligence and legitimate purview. It has been held, my lord, in paragraph 8.5. Now, my lord,
I'm just expanding, I'm just thinking aloud
my lord,
to expand your submission and then uh, get the feel of it.
my lord.
You see, the next coming Sunday, which is on
My lord,
21st,
my lord.
the registry will be closed. Now, your very good friend, Mr. Jainal Abedin, is sitting behind you.
My lord,
He has to file a suit by 21st, otherwise it will, the appeal if not filed within 21st will be barred by limitation.
Right.
So what he does is, he gate crashes the High Court. He's a powerful man, he breaks away the gate and window and then
Windows, right.
files the appeal here on 21st. There's nobody to accept it, but he comes here, uses his muscle power and then throws away the memo appeal into the court premises.
my lord. No, my lord, that is not possible as
Yes,
well.
sir,
Here,
obviously.
here is also, my lord, no. My lord, if, my lord, I have to go by the
Then
facts.
you have answered the question.
My lord,
You see, here what had happened,
my lord,
there is a date, 3 dates, 11th to 13th.
13, my lord,
12th and 13th are Saturday and Sunday.
my lord,
Now in Saturday and Sunday, what Mr. Dubai will do?
my lord. He cannot.
He'll have to go break the, what you call the, break the office, enter there with muscle power, and then throw it to the office of the registrar, and that's the end of it.
But I think there are other 2 open days was also the 13th and 14th, up to 15th. He could have, my lord. That's the word, my lord, due diligence and, my lord, kindly,
I mean, it's not defamatory. It's a demonstration of your strength. So don't feel bad about it.
No, no, my lord. My lord, our respectful submission, my lord, is that, my lord, when they are so conscious, they know the provision of the law also that we should approach. My lord, then the due diligence part, they have not reasonable diligence, they have not applied, my
No,
lord.
but tell me,
My lord, if we go by
if we
my lord,
understand the limitation act,
my lord,
then anyway, if you read any article of the limitation act,
my lord,
any article of the schedule to the limitation act, you will find that the first day is excluded by default. For example, if today for some reason at 3:30 we have a reference,
my lord,
and while at the end of the reference at 4:30 p.m., the court announces that the judicial work, the further work in the judicial side shall remain suspended. It is at 4:30. Our court timing is till 4:30,
my lord.
but at 4:30 that declaration is made. According to my understanding, I may be wrong,
No.
subject to how you convince me, is that the limitation for that day stands extended, even if the court functioning is stopped for even for a moment. The limitation, applies and the time gets extended. today's date will not be counted for the purpose of calculation of limitator. Even if the court functioning is stopped for a minuscule moment of the day.
Mal,
That is what our understanding is.
mal.
If,
No, my lord,
on-
if
if
the
the
office.
results are declared on 11, what is the date, 10th or 11th?
10th.
Result-
10 to 5, 10 to 5 PM.
10th gets extended,
Mal,
so 11, 12, 13 is Saturday and Sunday.
13th and 14 was there, my lord. 10,
11 and 12 also.
11, 1, 12 was there, my lord, but 13 and 14 was a Saturday and it was last date, my lord, 15th of the last date. So, my lord, there are two open days was, were there, my lord, but they have not invoked. That day. So, now, my lord, if we go by the provision of this entire statutes, my lord, they have not, who are they? It is not very clear. Now, my lord, from the very beginning of the, my lord, notification of the election notice, my lord, there are certain provisions, my lord, if they are agreed by the various provisions of the, my lord, defect in the voter list or the other defect, which there are provision in the statute also, which they have missed, my lord. Only after this election is over, my lord, then only they have come up with this complaint and lodged it before the, my lord, register. That too, my lord, after this period is over, my lord. Though now it is an subject matter of examination, my lord, that whether this period can be excluded, these two, my lord, holidays, my lord. My lord, if we go by the, my lord, provisions of the, my lord, statutes, my lord, the election was held on 10/5/2023, my lord, and there were only 15 valid nominations, my lord, was there. And out of these 15 valid nominations, 15 were accepted, my lord. And then, my lord, the joint representation of the appellants and other was received only on 15/5/2023 at 11:40 AM. So, my lord,
Come
this
to page
with
101,
my lord,
come to page 101.
101 of the appeal memo, my lord.
Yes, yes. Election
My
was
lord,
on 10th,
my lord.
correct?
Yes, yes, my lord.
Now, this is the, this is the
Notification.
part of the writ petition,
Yes, yes, my lord.
constituting a notice.
Notice, my lord.
Come to serial number 9.
The
counting of votes
the
shall
counting of
start
votes shall starts at 10 AM of
on 12/5.
my lord. In the temporary go down of the society, my lord, what has happened here is no option of the counting because, my lord, the out of 15, my lord, board of directors, only 15 nominations were there. So therefore, my lord, all 15 had been, there is no, my lord, election was there, my lord.
Yes, yes.
So all nominated persons were elected, my lord, and uncontested, they have got the, my lord, their name included in the board of directors, my lord. My lord, and the results were declared on the same day also, my lord.
What is the term of the, board?
5 years, 5 years, my lord.
5 years.
5 years, and the petitioners, my lord, did not participate in the election also, my lord.
Just a minute, Mr. Dubey.
My lord,
In which part of the writ petition you have pleaded that you have submitted the representation?
my lord. So there is also an acknowledgement, lord.
No, first you,
Yes,
that statement, pleading. Where have you stated that was acknowledged? There was no seal. So let us go to paragraph 17. of
My
the
lord.
document. Page 85.
My lord, page 85.
Please read. Please read
Page
page 85.
That the petitioner, there is some interested members of the committee who were active in participating in the state election with the irregular voter list were affected by the Honorable High Court's order dated so and so. Honorable Court, after knowing about the state order of the Honorable Court and subsequent submission of the representation dated 12/5/2023, state interested members continuously pressurized Mr. Akasuddin to withdraw his representation dated 12/5/23, which was submitted before the respondent number 2, along with the copies of the Honorable Court's order dated so and so and the report. Subsequently, the present petitioner and some other members of the committee came to know that the said petitioner, Muhammad Akasuddin, was forced by some other members to sign on some papers pretending to withdraw his complaint as alleged in the writ petition. After knowing about such acts on some other interested members, immediately thereafter, the petitioner along with 7 other members of the Samiti by their petition dated 13/5/23.
Dated 13/5.
13/5. It was
Requested respond number 2.
to refrain from considering any withdrawal letter that may be presented.
So it
before.
was dated,
Yes,
but where is the receipt? The statement regarding receipt of it.
but there is not endorsement,
So
Lord.
where is the statement?
But that
In the
statement
writ
is,
petition.
but that statement is not there,
That is
That-
missing.
my lord. But it's,
And otherwise, this, the
Well-
other repetition,
my lord,
where the single judge was directed to submit a representation within a stipulated period of time,
my lord.
that you are not the petitioner.
No,
So you go by simply by rule 27,
my lord,
right?
my lord.
So where is the statement that it was received by response number 2?
My lord will kindly come to page 152.
That I have seen.
That endorsement is there.
Where is the pleading statement?
No, that pleading is not there, my
So
lord.
we have
What
to
is this?
infer.
My lord, because this is
No
a,
statement,
no, no.
no statement,
My representation is dated, my lord. They have also not disputed it.
no signature, seal, no seal,
My lord, that
no
part,
seal.
with due respect, my lord, that part of,
It
that's
is an
correct.
admitted position, no seal.
yes,
Somebody, a senior assistant, received 15/5/2023
my lord,
at 11:40 AM.
my lord,
Now come to the MP note.
my lord.
There is no mention about that petition. Absolutely silent. Page 155.
My lord. That is our case, my lord, that he
That
has,
is your case. First,
while considering
First-
it, my lord,
writing a representation on 13/5/2023
my lord,
is one method which was on second Saturday.
my lord,
You wrote it on
my lord.
representation. But there is no statement that where it was submitted and receipt of the same was acknowledged
My lord.
by response number 2. There is absolutely no whisper.
But in support of that,
Now,
my
you
lord,
have taken to an endorsement,
my lord,
asked to an endorsement
yes, yes,
without any supporting pleading, to an endorsement of some senior assistant, which was not endorsed with a seal. Now, in the read appeal,
my lord.
where is the foundation laid
Look, my response to your
for
lordship's query,
applicability
my
of
lord,
Rule 27,
my lord,
plus all the provisions of the Limitation Act to become a question of law?
my lord,
First, there has to be undisputed facts.
my lord. But so far as this fact is concerned, my lord, nobody has disputed this aspect of the matter.
No, that does not mean.
My lord, my submission
Where
for
is
you,
the pleading now? In the, okay, read petition, it was not there. In the appeal,
my lord, we are relying upon this endorsement, my lord.
no, where is it, in the read appeal?
The same facts have been narrated. Same facts have been narrated.
See,
After some of the, immediately thereafter, along with 7 members, Samiti by their petition dated 13/5/23
So what is
requested the respondent.
statement regarding receipt of it? Let us assume for a moment, but by the senior.
Milord,
So where is that
Milord,
statement?
that specific statement is not there, Milord. I cannot
Where is
improve
not
the.
there?
But we say that we have submitted representation dated 13/5.
Representation dated 13/5.
My lord.
13/5 was a second Saturday otherwise. Writing a representation
Yes,
at
yes.
home,
My lord, I have
It's a
written on
different
13th. Yes,
right?
my lord,
We can write the
My lord.
backdated representation.
my lord.
Question is about laying the foundation for raising a question of law. Right?
My lord,
And the facts are to be undisputed.
my lord.
That you have been making submission.
Yes,
But where is the foundation laid?
but we,
That this was received by a senior assistant on 11:40 AM on 15/5/2023. Where is the statement?
my submission for your lordship
Every,
considered,
in a writ petition,
My
if
lord.
it is not a civil suit,
my lord,
nobody comes here to lead evidence,
My lord.
except in rare cases,
my lord,
right?
my lord,
Oral evidence.
my lord,
So everything is to be pleaded
my lord.
so that the other side can respond. Now, where is the statement that on 15/5/2023, the receipt of the representation was acknowledged by a senior assistant of from the office of the respondent number 2? Where is the statement in the writ petition or in the writ?
Subject.
Because we are arguing,
Yes, yes.
both of you are arguing a question of law.
Yes,
But
yes.
to raise a question of law, one has to be sure about the facts and the foundation laid.
My lord, and there is no dispute as
No
regard that.
point wasting time
My
in
lord.
raising a question of law. 100 questions of law can be raised.
My lord,
But question is, first, court has to be of court of facts.
my lord,
And for question of law, it has to be undisputed fact. Now, where is the statement?
but I'll,
What is not pleaded?
my lord,
What is not pleaded in a writ petition, then that fact should not be argued.
my lord, I'll respond to your lordship's query in this manner, my lord. My lord, with my limited knowledge, my lord, I know, my lord, that in a civil suit, you have to plead facts and lead evidence. So far as writ is concerned, my lord, to my limited knowledge, it's a combination of both. Since it's a petition on oath on affidavit, my lord, the documents that is submitted before your lordship.
So as the original endorsement receipt.
But that is there with the authorities, my lord. Let them produce that record. My lord, nobody has denied. Your lordship would see.
No,
My
question of denying is not there.
my lord,
Mr. Dubey,
my lord,
firstly,
my lord,
in a writ petition,
my lord.
it is to be pleaded.
Yes,
So
my lord.
that the other can respond by way of filing a counter,
My lord.
right? The statement is not there that it was the representation was received by a senior assistant from the office of the respondent number 2. That is not there. Where to respond?
In fact, my lord, if your lordship would see, the learned
I
single,
can see everything.
my lord, learned single judge has also proceeded, my lord, on that basis. That remains facts, my lord. That has not been disputed. My lord, there is no counter to it, my lord. My lord, I admit, my lord, there is no specific averment to show. But from the writ petitions along with documents, my lord, it's my lord, proved that it's been received on 15th. That has been taken note of by the learned single judge, my lord. They are not in appeal before your lordship, my lord, on that fact. My lord, see para 8 of the judgment. My lord, kindly have a look at para 8 of the judgment, my lord, page 176.
8,
Yes.
170.
6. Somewhere in the middle, my lord. However, from the annexure G to the writ petition, WPC, it is seen that the petitioners in both the writ petitions before this court submitted a joint representation which was received only at 11:40 a.m. on 15/5/23. So, my learned single judge has considered it, my lord. It's a finding of fact by the learned single judge, and my lord, they are not in appeal, my lord, they have not challenged it, my lord. And my friend has also argued on that basis, my lord, it was received on 15th. But it could have been better drafted, my lord. I understand.
No, it is a case of clever drafting also, paragraph 17.
Blood, clever, rather, blood, if I can use that word, blood, is detriment to the client only, blood, if it is so clever.
No, it is a case of lawyer drafting the petition,
Yes, yes, yes.
not a case of the client drafting the petition.
No, no, blood, it's a lawyer, blood.
Shambhu Vaishnav is not a
No, no,
lawyer.
but we, rather, blood, we could be blood, more diligent, blood.
Yes.
And blood, the response to my learned friend's judgment, blood. Okay.
Now, my lord, if we go by the judgment, the paragraph 8, which has been relied on by my learned friend, my lord, it is, my lord, because as the matter was placed before the learned single judge, now the issue which they have raised regarding the two dates, my lord, that is Saturday and Sunday, this was never raised, my lord. So therefore, for the very first time, they have raised this issue regarding that the General Clauses Act will help them to, my lord, count this 2 days of his vacation time, my lord. So therefore, my lord, as there was no question, my lord, no issue has been raised before the learned single judge, they can, my lord, best go back to the learned single judge again, my lord, and can raise this issue, my lord. This is not an issue which has not been decided by the learned single judge. Now we are in an appeal, my lord. That is another aspect. So therefore, my lord, the issue which has been raised that the whether this is within the period of limitation or not.
What ground the register order has been chilling?
Lord, the
Petition.
Lord, the ground which they have raised is that, my lord.
In the writ petition.
Yes, yes, my lord. In the writ petition,
Where are the paragraph?
paragraph, my lord, maybe 3 to 5 starts at page, my lord. From para 19, my lord. Paragraph 90 to page,
Just a minute.
my lord, 90.
Of course.
Lord, their ground starts from, as my lordship has raised a question, my lord. I have found that from paragraph 23, my lord, basically they have said, my lord, that the registered cooperative societies, though in paragraph 23 at page 91, my lord, that the petitioner stated that even after submission of the petition dated 12/5/2023, along with a certified copy of the honorable court's order dated and the copy of the writ petition by the writ petitioner so and so, the respondent number two surprisingly in his order dated stated that no petition was received between 11/5 to so and so, which is a false and misleading. Before passing the order, the respondent number two did not verify the relevant records, which includes the voter list of so and so, so and so. The said order of the registered cooperative societies Assam clearly reflects that he passed the order dated on the basis of the subsequent petition dated submitted by the said writ petitioner MD Clasuddin. The said order dated 20 passed by the respondent number two is illegal, improper, arbitrary, and without the authority of law, as well as the violation of the order dated so and so. The action of the respondent authorities are acquitted with a malice and facts as well as in malice in law and vitiated with biasness, hence the same being illegal, arbitrary, unreasonable, so and so, my lord, is liable to be set aside and quashed. Now, my lord, from this very issue, my lord, they have not averred anywhere, my lord, as my lordship has already taken into account that this has been acknowledged or received by any authority or by the my lord officer who has signed it. Now, my lord, if we peruse my lord, that representation, I'm just, my lord, drawing my lordship's attention to the representation which they are relying on. My lord, is available at page, my lord, page number 151, my lord. Just for a moment, I am reading it, my lord. What is their contention before the register, my lord? 114. My lord, I am troubling my lordship, my lord. The type copy starts at page 149, my lord. My lord, may kindly peruse this. The very first subject is the defective voter list illegally prepared for holding the election of the board of directors of Gandhi Gram Samavay Samiti in Nitai Nagar, Karimganj. My lord, this is vital because under the statutes, my lord, when the voter lists are prepared, if somebody is aggrieved with the voter list, there is a statutory prescription, my lord, that the voter list can be objected into. Now, my lord, that forum they have not invoked into. My lord, their contention is that we, the undersigned, members of the Gandhigram Samavay Samiti, beg to draw your kind attention to the following with a request to take necessary action in the matter in accordance with law in terms of the order passed by the Honorable Gauhati High Court. That on 25/4/2023, a notice was issued for holding the election of the managing committee of the Gandhigram Samavai Samiti on so and so for the period of 5 years, that is from so and so to so and so. After going through the said voter list, some of the members of the Samiti found some serious irregularities therein. Accordingly, a few members submitted their petition to the returning officer Gandhigram Cooperative Society Limited, requesting to direct to exclude the name of those persons illegally enumerated in the voter list of 2022-23. However, even after filing of the petition dated, the authorities did not take any action in regard to the request made by the said members. That in above the premises, one of the members, namely so and so, approached before the Honorable Gauhati High Court by filing the writ petition number so and so, seeking redressal. It has also come to our knowledge that the Honorable Gauhati High Court, by its order dated, disposed of the above writ petition, directing Your Honor and the Assistant Register Cooperative Society so and so, Nagar Karimganj, not to give any approval to the AGM of the election which was to be held on so and so, prior to deciding the grievances of the petitioner in terms of the Rule 27 of the Assam Cooperative Rules 2019. And the said petitioner was directed to submit a representation along with a copy of the said writ petition before Your Honor between so and so and so and so. The Honorable Court in its order dated 8/5/2023 further directed that till a decision is taken by Your Honor, the AGM of the elected body will not be given in the till approved by Your Honor and the Assistant Register Cooperative Society so and so, and the departmental officer will run the society till a decision is taken by the competent authority. That pursuant to the above direction, the said Akhlasuddin accordingly submitted a representation before Your Honor along with a copy of the order and the relevant document which is pending consideration before Your Honor. However, meanwhile, during pendency of necessary inquiry from your end, the undersigned members have come to know that the above petitioner, that is member of the sole society, namely Akhlasuddin, has been forced by some other members to sign on some papers pretending to withdraw his complaint as alleged in the writ petition. That since the matter has been finally disposed of by the Honorable Gauhati High Court with the necessary direction, on the being satisfied with the irregularities and oblique or illegalities committed in preparation of the voter list and the compliance of which pending before Your Honor, the such acts of the few members amount to disregard to the direction of the judicial authority. We therefore respectfully request Your Honor to refrain from considering any such withdrawal letter that may be pretended for said so and so, except the direction of the passed by the Honorable Gauhati High Court in so and so. So, my lord, if we go by the contention raised before the registrar cooperative societies, my lord, is basically the voter list which was prepared, my lord, prior to the election. They are not satisfied and happy with the voter list. My lord, if in such a situation, my lord, the statute is very clear, my lord. My lord, may I be permitted to draw my lordship's attention to section 41, my lord, of this Assam Cooperative Societies Act 2007 elections. My lord. Section 41 elections, the superintendent's directions and control of the my lord, preparation of the electoral rolls for and the conduct of all election to a cooperative society shall vest in the registrar. It shall be the duty of the registrar to prepare the voter list with eligible members to arrange for holding election of directors, delegates or representatives to the delegate general body and representative of the society if fallen vacant. The election of directors to a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board, subject to the provision of the Constitution of India so and so, where complaint is now, my lord, along with this, if somebody is not happy, my lord, with the the voter list which is prepared, my lord, pass. My lord, then the provision of this Assam Cooperative Societies Election Rules of 2019, my lord. Rule 3, clause H is relevant, my lord. Rule 3, clause H, my lord, in page 110 of this manual is available, my lord. The concerned chief executive / secretary of the society shall prepare and submit a list of members eligible to vote in the election as per section so and so of the act to the registrar / election authority for counter signature to fulfill the requirement of section 41(1). The registrar of cooperative societies and the joint registrar of the cooperative societies, deputy registrar of so and so societies, in exercise of their delegated powers of the registrar, shall ensure correctness of the voter list after deleting names of dead voters in consultation with the registrar of the births, deaths, incorporation of the new voters, removing duplicate name, etc. by inviting claims and objection and comparison with the registrar of membership, etc. Now, my lord, the election authority shall arrange for publication of the electoral roll before 30 days of the date of election. Nomination from candidates shall be received so and so. Election withdrawal of nomination shall be done so and so. Last list of contesting candidates shall be finalized 8 days before the election, and the printing of ballot papers shall be so and so. Wherever the society fails to prepare and submit the electoral roll of so and so, the election authority shall himself or through a person authorized by him on behalf of prepare the electoral roll as per so and so. Complaint to conclude. Now, my lord, in while, my lord, this in clause H, my lord, if somebody is not happy, my lord, with this, my lord, preparation of the electoral or the list which has already been notified, can raise the authority before by submitting a representation or an objection, my lord. Now, my lord, these petitioners, my lord, Shambhu Vaishnav or the Aglasud Shambhu Vaishnav, my lord, has never raised any such objection before the authority, my lord, that this voter list or the electoral roll which had been prepared is not in accordance with law. Now, my lord, they have come up. So, my lord, in rule 6 also, my lord, thereafter, my lord, what will be provision has been nomination papers shall be filled in, my lord.
These four occasions are listed. They have not participated in the election.
Representation between the 11 11.
Election notification change করা, election of result থেকে change করা, change করেছে approval 26 বলে লেখা এখনো change পাওয়া না। হ্যাঁ
There are the institution of culture.
হ্যাঁ
So nomination থেকে মানে আছে So, my lord, thereafter the time, my lord, if the procedure of this rule 4(3) is 3, 4, and 5 is over, then the my lord issue of the nomination of come, my lord, filing and scrutiny of the nomination papers. The nomination paper shall be filled in form number 1, my lord. The entire procedure, my lord, had been done in accordance with the rule. No, there was, my lord, no question had been raised whatsoever by this, my lord, writ petitioner at any point of time. My lord, at the time of, my lord, preparation of the voter list, there was no objection has been raised by them. Then, my lord, the preparation of the voter list also done. It has been finally notified, no complaint, no objection whatsoever, my lord. Then the publication of the electoral roll before 30 days of the election had been done. No objection has been raised. Then, my lord, the scrutiny of nomination. My lord, when the issue of,
Mr. Bhuya,
My lord.
by rule 26,
my lord,
he has a right to file an.
no, my lord, rule 27 is there.
Right. Whatever right is available.
My lord, that is there,
Rule
that is there.
27 right is available.
That is there, my lord. No, no, my lord,
He requested or waived earlier right
my lord,
of raising the
My lord.
issue at
My
an earlier point of time. By rule 27, he can raise a dispute.
no, my lord, it is there, it is there. That is not
Question is,
disputed, my lord.
narrowed down to a thing. Whether 3 days.
That counting
whether
is, that counting is, my lord.
Stated to have been prepared on 13/5/2023,
My lord.
was submitted on 15/5/2000.
My lord, the issue is now in a very
Whether the
narrow compass.
operation of
My
law
lord.
under section 9 and 10 of the General
My
Procedure
lord,
Act,
my lord.
whether that's benefit to be available.
Available to
And
them
now
or
to
not.
the point that whether this ground or the question of law can be raised at any point of time,
My lord.
and a question of limitation can also be raised at the last stage also. No dispute to the proposal.
Not now whether.
The question is that
My lord.
to raise such question of law or the ground of point of limitation, whether the facts are sufficient or not.
That is the issue, my lord. Now, my lord, even if, my lord, the writ appeal is allowed, my lord, on this issue, my lord. My respectful submission, my lord, is that, my lord, whether this counting or the limitation of, my lord, can be condoned or not by the registrar by taking into account of the general clauses act of section 9 and 10. That is also an issue, my lord, regarded to be decided, my lord. My lord.
May or fail. Otherwise, register, so period of limitation is there, it has no power to control.
My lord. One, my lord, judgment I have. একটু কোনটা? দুটা কপি আনিছেন না আমি এটা এইটোতো একো নাই পোৱা ন? Only the limitation can be condoned. Now, সেই limitation to condone কৰিব যাওঁতে section 10 আৰু 11 of the LBC to apply হ'ব নে নহ'ব এইটোতো ইয়াতে decide কৰা আছে। So 26 and 1. Yeah, my lord, a petition is pending before, my lord, before this honorable court, my lord, whereas the same question has come up. My lord, that is Gulzar Hussain, my lord, we have given the order there also, my lord. Just referring, my lord, it has not yet been disposed of, but the same question has come up that whether the registered or cooperative societies, my lord, can condone the delay of.
Absolute proposition, no point.
My lord.
Supreme Court has settled.
Settled in Reggie Thomas case, my lord.
Reggie Thomas, Nohordal Barma.
My lord, my lord. So, my lord, therefore, my lord, my respectful submission, my lord, is that, my lord, this General Clauses Act, by applying the same provision, the principle. Lord, the may, Lord, if you go by the provision of this, Lord, rule. Lord. 27 no? Unlimited physical. The directory. My lord, if we go by the provision of the rule, my lord, 27, that is the redressal of disputes. Any dispute relating to election of a cooperative society may be submitted within a period of 3 days from the date of declaration of the result before the election authority. The election authority shall make an inquiry upon the dispute on the basis of the relevant records and pass necessary orders. So, my lord, both are required to be, my lord, read together, my lord. Then, my lord, it should be shall will come, my lord. If I am, my lord, subject to correction, if I am not wrongly understood, my lord. So therefore, my lord, it is a mandatory requirement, and though they have said, and my lord, the honorable learned single judge has also, my lord, what is there on record, my lord, I am not disputing, my lord, and I will not submit in that line also that they have not submitted or it was not there on record. My lord, in fact, an affidavit has also been filed wherein they have admitted it, my lord. Now the issue is that, my lord, that in a very narrow campus, my lord, that whether by applying the provision of section 10 and 11 of the General Clauses Act, the limitation can be condoned by the, my lord, registered cooperative societies or not. As per my, my lord, respectful submission and limited understanding, my lord, if we go by the various provision of the law, the registered cooperative societies, my lord, cannot, my lord. So therefore, my lord, the learned single judge was in the order when it was passed, my lord, was in a right context, and that's why, my lord, they did not, my lord, averred or pleaded anything regarding, my lord, General Clauses Act before the learned single judge, my lord. It was a complete silence they have maintained. Only on this, my lord, appellate forum, they have bring this issue, my lord, although this is a question of law, my lord. My
You have said that in the affidavit, they have accepted that position. I
my
don't find it. Which affidavit you are referring to?
lord.
The affidavit in this matter was filed on 5/2/2026 by respondents 1 to 4.
No, no, my lord, it is the affidavit in opposition. An affidavit has been filed in writ appeal, number 343 of 2024, my lord, it is on record, my lord. My lord, I
No,
have,
which there, but it's not admitted that.
my lord,
They have received it.
my lord, I have to, my lord, bring to my lordship's notice, my lord. If, my lord, in page 181, my lord,
It says 17.
page 181, running page, my lord.
It says 17.
Yes,
On 17th one, Akasuddin.
Yes, one Aklasuddin of cooperative
Submission
society.
of 15th is not admitted.
As no grievance petition was received in between so and the earlier petition. Yes, my lord. Only they have said that, my lord, Aklasuddin was there, but 11/5 to 13/5/2023 petition was volunteered. Therefore,
Because
the
we have
state.
taken note of that. When my brother asked that question, we took note of this.
My lord, my lord.
In this affidavit, it's not there.
Yes, my lord.
You see, rather in page 183,
Yes, my lord. In annex.
they said in present case, election to so-and-so was held on 10/5 and a complaint regarding anomalies in voters list was submitted on 17/5. We took note of that, only then we are asking that, my brother asked that question.
My lord, my lord, may I read the page 182? It is a continuation of, my lord, paragraph 6, my lord. Para 7, 183, para 7 is also there, my lord. It is seen that the petitioner in both the writ petition before this court submitted a joint representation which was received only at 11:14 AM on 15/5/23. Yes, no. Letter on the same was withdrawn. It was Aklasuddin's কথা কি বলছেন, not the petition filed by with Shambhu Vaishnav. Lord, what I have understood from this affidavit, my lord,
Yes, they have admitted. We
my
have
lord,
read it.
my lord. We have to be to the notice of the honorable court. No, it's not fair.
And yes, Mr. Bordolay, what do you have to say?
Also, otherwise the rule 27 of the election rules. The shall and may is your lordship, that is to be decided, your lordship. When that apart, it is an admitted fact that the registrar doesn't have the power to condone the delay, your lordship. And rightly, wrongly, they have submitted their representation, which was received on 15/5, your lordship. 13 and 14 was Saturday and Sunday. 15 is a working day, it's on Monday, your lordship.
So 10th of May is to be excluded.
10th of May is to be excluded.
So that means.
That means 11th, 12th, they have 2 days, and another is 15th, if we exclude these Saturday and Sundays, your lordship.
I mean, the office is closed on 13th and 14th,
13 and 14 days close. Yes, okay.
and 15 is the reopening.
15 is a reopening. Rule 27 says 3 days immediately from the date of declaration of the results, your lordship. 11 and 13, that was
Okay,
Millet, I have some.
yes.
I am obliged to my learned senior friend, Milord, to have read rule.
He has read what you missed.
Yes,
Yes.
Rule 27. Any dispute relating to election may be submitted within 3 days from the date. B, your lordship would see the electioners shall make an inquiry. So in the same provision, my lord, when shall and may are there, my lord, there has to be a distinction. If the intention of the authority of legislature or the rule making authority was that it would be a mandatory, my lord, then that shall ought to have been used there.
Shall is correctly used. It can't be substituted by may,
But that's why, my lord, I am saying that may cannot be read as well.
Because you see, a person aggrieved may file, that means he may not file also.
Yes, yes.
But once a complaint is filed, then the registrar shall.
My lord, if your lordship would see, my friend has read para 18, 19, my lord, that genesis of the dispute lies in para 5 of my writ petition. For a moment, if your lordship would see. Page 75, my lord. If your lordship permit, my lord, may I read, my lord?
Para 5 of the.
Writ petition, page 75. The petitioner states that after knowing about the election notice dated so and so, which was affixed along with the voter list dated 10/5/22 in the office of Gandhigram Corporation of the year 2022-23. The petitioner and other members of the said committee found serious irregularities which was published backdated. It has also come to their notice that the said voter list has been prepared and published illegally, entering the names of respondent numbers 7 to 12 against their family members who are still alive. But the Act Section 55, if your lordship would see, that doesn't permit. Further, the names of respondent number 13 and 14 illegally entered into Part 2 voter list of 2022-23. It is to be mentioned here that the respondent number 13 is a resident under the jurisdiction of the Kalinagar Gram Panchayat, which is under Ramakrishna Nagar Cooperative Society. Hence, he is not entitled to vote or to contest the election on 10/5/23. So far as respondent number 14 is concerned, his name has been illegally entered in the Part 2 voter list of 22-23 against serial number 109 in place of one Sri Sajal Das, whose name was entered in Part 2 voter list of 2021-22 against serial number 109. Since respondent number 14 is neither a legal heir nor a family member of Sri Sajal Das, his name could not have been inserted against the serial number 109 of the voter list of 23. In place of Sajal Das under Gandhigram Samiti, the above fact clearly reveals that the respondent authorities prepared and published the said voter list of Gandhigram Samavai Samiti along with the election notice on so-and-so, violating the provisions of so-and-so. It is pertinent to mention here that the said voter list was published 1 year prior to holding of the election on 2023-28, thereby illegally allowing respondent number 7 to 14 to contest the election and to cast their votes in the said election on 10/5. There are total 2639 members of voters in Part 1 voter list and 114 members in Part 2. Following are the respective source we have indicated. Now, my lord will also look into page 53 for a moment. If you my lord, kindly have a look at page 52 for a moment.
52.
Yes. This is dated 2/4/22, my lord. Has your lordship got it, my lord? So financial year will be 22-23. Now your lordship kindly come to page 53. This is part of the proceedings. Miscellaneous first. In the Sabha meeting, suddenly the chairman of the committee submitted 8 numbers of application in the meeting. The application is to change the membership in the committee for 22-23, while his father, brother is alive, and to enter their names in the voter list. Out of these 8 applications, one applicant does not belong to the area of the society. In the Sabha meeting, the secretary informed the chairman of the committee along with all BODs present in the Sabha meeting regarding the rules and bylaws of the committee. In the Sabha meeting, the secretary of the committee clearly informed that according to the rules and bylaws of the committee, the said applications cannot be worked out, but all the BODs present in the Sabha meeting were unwilling to accept the contentions of the secretary. Thus, the secretary did not agree with the above mentioned. So, my lord, an objection was raised. My lord, this is regarding membership, which is clearly violation of section 55 of the Act. Now, my lord, your lordship would also see page 101, my lord.
Mr. Dubey,
Lord, I am not going on the merits, Lord, because my learned.
you have raised certain disputes
Yes,
in your petition
my lord.
and presentation. And the different point of time in the requisition.
My lord.
Question first is to cross the first hurdle,
My lord.
27A.
My lord.
If we find that all that petition is
My lord.
within time,
My lord.
then it is a register who has
Yes.
been vested with the authority and jurisdiction to decide under Rule 57B.
My lord.
So,
Hmm.
it's the appeal hinges on that point only.
I'm obliged to your lordship. Only because my one learned senior friend had said I could not have raised that issue.
Point.
Only your lordship would see one page for my satisfaction, Lord, page 101. This is the part of the nomination papers, my lord.
No, 101 would be part of
Nomination.
notice.
Yes, yes, part of notice. Just one clause I am drawing your lordship's attention to. Clause 5, my lord. The intending candidate must have attended at least 2 meetings of the general body of the society during the last 5 years. My lord has seen on 22, in the year 22, with the minus I have read out, my lord, there they had entered into the membership list. They have not even completed 2 meetings, my lord. Their nomination ought to have been cancelled, my lord. Lord, it's a classic case of backdoor entry, my lord. And Lord, subject to my information, Lord, no affidavit in opposition opposing all these aspects of the matter has been filed by the private respondent. I stand corrected, my friend has filed it, Lord. So, Lord, once an inquiry, and Lordship, kindly see that order has been passed. Why?
We are getting the order.
Lord, one more aspect can I show to your Lordship, Lord, just for last one. Why that order is referring a date from 11 to 13, that I'll like to clear to your Lordship. My lord, at page 140, the earlier round of litigation was there, where your lordships directed in para 4 that the petitioner in that case would file a representation between 11/5/23 to 13/5/23.
That
And
will not bind you.
No, I'm not binding. Lord, what I'm saying is registered had looked into this representation. He has ignored my application. And that's why he said that I have found that nothing has been filed between 11 and 3. And Lord, I reiterate, Lord, that your Lordship would treat Lord, Rule 27 as directory, Lord, as well as the provisions of General Clauses Act, Lord.
But Mr. R. Dubey, hello. Mr. Here done it. Senior counsel assisted by
He was saying, we are appearing in
counsel for the. So you are assisted by?
my,
You saying.
my,
The following is
7 to
7 to
22.
23. So before that, it is Mr. G. Borrell, attorney for the Corporation Department, representing responding numbers 1
to 4, Your Lordship.
4. For others, nobody is there. 23, your name? RH? RH Chaudhary. It's from 23. None of this or other response. Next. We'll just take a short break and come back. By filing this inter-court appeal, the appellant has assailed the impugn judgment on order dated 12/8/2024, passed by the Honorable Single Judge in WPC P499 of 2023. In the writ petition, the appellants had sought redressal for a dispute by filing a representation along with the writ petition the dispute is with regard to election as well as the annual general meeting of the society under the name and style of Gandhigram Samabhay Samiti Limited, which is registered under the Assam Cooperative Societies Act. One shareholder, namely Mohammed Atlasudin A.K. alias Uddin, respond number 23, was aggrieved by the preparation of electoral rolls of the said society, filed a writ petition which was registered as WPC 3499 of the 2023. This court, by an order dated 8/5/2023, disposed of the writ petition with an observation that the election, that the registrar of the cooperative society, along with the assistant registrar, not give any approval to the election of the AGM to be held on 10/5/2023, prior to deciding of the grievances of the respond number 23 in terms of Rule 27 of the Assam Cooperative Societies Election Rules, 2019. And the said respondent was allowed to submit a representation along with a copy of the writ petition with regard to his grievances. Full stop. Next, it would suffice to mention that the election notice dated 25/4/2023 is admittedly not under challenge. And in the meantime, the election results were declared on 11/5/2023, pursuant to elections which were held on 10/5/2023. For the grievance of the petitioner is that pursuant to the said election, the petitioner and others had submitted a representation dated 13/5/2023 to the registrar of cooperative societies, Assam, with copies for information to the assistant registrar of cooperative societies, R.K. Nagar, the inquiry officer, care of the assistant registrar of cooperative societies, R.K. Nagar, the secretary, Gandhigram Cooperative Societies Limited, and returning officer, Gandhigram Cooperative Societies Limited. So he said, obtain regarding defective voters list. And the anomalies of the election was received by one senior assistant in the office of the registrar of cooperative societies from Assam on 15/5/2023 at 11:40 a.m. The registrar of cooperative societies from Assam by its order dated 26/5/2023 referred to the writ petition filed by the respondent number 23 and by referring to that the fact that no petition was received between 11/5/2023 to 13/5/2023. Took note of the representation of respondent number 23 filed on 17/5/2023. Accordingly, no, not according to from whereby he had withdrawn the petition filed with reference to the writ petition. So accordingly, the registrar of cooperative societies from R.K. Nagar was permitted to accord approval to the proceedings of the AGM as per section 45 of the Assam Cooperative Societies Act 2007. Accordingly, agreed by the said order dated 26/5/2023, as well as the elections held to the Gandhigram Cooperative Society Limited. The appellants had filed a writ petition. Had filed a writ petition which was registered as WBC 3499 of 2023. Amongst others, praying for declaring the election of the said society held on 10/5/2023 as void, semicolon, for setting aside and quashing the impugn order dated 26/5/2023 passed by the registrar of cooperative societies from Assam, semicolon, for setting aside and quashing of the letter dated 29/5/2023 issued by the assistant registrar of cooperative societies for granting approval to the proceedings of the AGM for the year 2023-24, which amounted to formation of Board of Directors of the said society for 2023-24 CO2 2027-28. Semicolon. Setting aside of the letter dated 1/6/2023 by the respondent number 3 granting approval to the proceedings of the first meeting of the said society with other consequential reliefs. Full stop. The 11th single judge by the impure judgment and order dated 12/8/2024 took note of the fact that the appellants in the present rate petition in WBC 3499 of 2023 and WBC 2439 of 2023 did not challenge the notice dated 25/4/2023. They were notifying the elections and also took note of the fact that in terms of Rule 13 within bracket A of the Assam Cooperative Societies election rules from 2019, if the valid nomination papers is equal to the total numbers of members to be elected to the board of directors, the returning officer was empowered to declare such candidate to be duly elected. And accordingly, the returning officer had declared the results of the election on 10/5/2023. Therefore, the submission of representation which were received only at 11:40 AM on 15/5/2023 was held to be delayed and in clear violation of Rule 27 of the Set 2019 rules. Held that the said representation could not have been taken into account, and accordingly was held that the impugned order dated 26/5/2023 did not call for any interference. Next matter. In this intercourt appeal, in order to assail the impugned opinion dated, the impugned order dated 12/8/2024, the learned counsel for the appellants has referred to the provision of of the seventh copy bylaw. Permits exclusion of the first day in series of days and the extension of time if the court or office is closed on the last day of prescribed period of limitation. And accordingly, it is submitted that the elections were, the results were declared on 10/5/2023, and therefore by excluding 10/5/2023, you can actually put that paragraph 4 of order dated 22/11/2024. Put on your speaker, I'm not hearing you. Just see. For example, which item? 6, you'll have to wait. These are 2019 matters. All matters today are 19 matters. Hmm? No, unless we look at the records, we're not adjourning. Because all of these are all matters.
I will go through the PCR of the item number 3.
Item 3.
3 minutes.
Ah.
Go through the PCR.
First, item 1.
May I please your lordship? This case filed against the order of this court for review because subsequent development of the case lordships because due to discovery of new ground also and subsequent orders of the tribunal also lordships. Here is the instant case lordships. Initial enquiry was done on 17/2021 by the investigation officer. On that basis, notice was issued. In the enquiry, it has been stated that petitioner is the daughter of Ikram Ali. And my husband's name and two children's names also appear. But I am the daughter of not late, the son of Didewani. I prove all the documents in respect of my father, son of Didewani. Learned tribunal held that since the reference is made against me, daughter of Ikram Ali, so I have failed to discharge the burden that I am the daughter of. Then declared me as a foreigner lost by approved the court. This honorable court on that way also held that since I have not called for any police report in this regard, so the tribunal judgment is quite in order and affirmed that. And further held that no pleadings has been made in respect of my uncles in the written statement, but suddenly he appeared and made deposition made before this court, before the tribunal. So on that ground also, that is also actually not correct, pleadings is there. And after disposal of this case lordships, another notice has been issued to me. The same foreigners tribunal. In that notice, my name has been mentioned and father's name has been mentioned Monser Ali, though I am the daughter of Sonobdi. On receipt of notice, I submitted, and on receipt of notice, and I asked for the documents and submitted application before the tribunal to clarify my father's name. Learned tribunal lordship by directed the appointed the police to make an inquiry in this regard. After inquiry made, found that I am the daughter of Sonobdi, not the daughter of Ikram Ali. Subsequent same officer, same court lordship. Subsequent notice said I am the daughter of Ikram Ali, initial Monser Ali. After inquiry, they found I am the daughter of son of the Devani, and case has been discharged. So on this way, lordships, I required lordship that it may be required lordships. I prayed for correction of this order, subsequent discovery of important ground lordship. Those lordships, first page 40 lordships. Initial case, my lord, first registered, page 40. Type copy prior to that lawsuit, that will better clear lawsuit for us. Page 40, inquiry report, form 1 lawsuit. First, column 1 lawsuit, my name, Rohila Khatun. Father's name mentioned lawsuit Ikram Ali. That is incorrect. When in column 4 lawsuit, Kofiluddin is my husband. Lawsuit will fall. And next page lordship will page 41, my husband's name, my two children's name has been appeared. On that count, I received the notice, lordship's address and others are found. I disputed in this regard regarding my father's name. And page 42 lordship will find left side inquiry, left side 70 2021 2001. and signatures of the officers also encourage Siddhi Kushan. On receipt of notice, I submitted a written statement, Lordship, that is page 41. I disputed also it. Page 48. Written representation, Lordship, will find page 48. Paragraph 3, Lordships. First paragraph of 2, Lordship, the allegation imposed upon the respondent by the complainant is flatly denied by the respondent, which is baselessly instituted against the respondent only for harassment. The second is important, Lordship, that the respondent is a born in India by birth and was born and brought up at village Singimari, PS district, Golpara, Assam, India also, according to school certificate. That Sonobdi Sheikh and Chambok Manu are the parents of the opposite party, and the opposite party is in illiterate Omani. That Amatullah Sheikh and Sanbanu was the grandparents of the opposite party. That number 6 is also important, Lordship, that the respondent's grandparents have 4 children, namely Sonuddin Sheikh, Monaruddin Sheikh, Monaruddin Sheikh. Monuddin is the DW2 in the instant case. And that there are 9 brothers and sisters of the respondents, namely so and so, so and so. Next, Lordship, paragraph, page 50, bottom, Lordship will find. Lordship got it. Paragraph 50, bottom, that the name of the respondent and the father has been recorded as.
See,
Lordship.
in this code,
Yes,
if we see paragraph 9, 10, and 11 of the order,
Lordship.
the plea of the Saika that the petitioner is not the daughter of great Ikram Ali, and the reason cited by the tribunal is disbelief, the said fact. Same can be explained otherwise, like petitioner failed to discharge burden because that he is not the daughter of Ikram Ali.
Lordship.
Correct.
Lordship.
And second again 10. Again, it says that you have failed to establish that you are the daughter of, not the daughter of Ikram Ali, and instead you are the daughter of Sonaddin Diwani. That issue has been decided.
And Lordship,
This could have
yes,
given the.
and even Lordship will find that also that this honorable court in the paragraph 7, Lordship, bottom, Lordship. Paragraph, page 75, that there is no pleading at all regarding my parents. Lordship, bottom, Lordship, last line,
No, but
the
this is a
said-
case of error apparent.
Lordship, that
See, that cannot be a case of error apparent. That is. a
and
case of
Lordship,
decision.
Lordship, in paragraph 9, Lordship, yes, this court has pleaded that Akram Ali and reasoned by the tribunal disbelieving the fact the petitioner ought to have sought for police report in our considered opinion is proper. The same can be expressed in the other way, that the petitioner failed to discharge the burden to show that she is the daughter of Ikram Ali. So, Lordship, that's important because subsequent notice, Lordship, the subsequent notice, Lordship, will find page 105, second notice, page 105. That notice issued to me. And enquiry report, Lordship, page 113. Certified copy that is Lordship, 130. Here my name written Rohila Khatun. Father's name Monster Ali. Officers is saying, earlier stated, I am the daughter of Ikram Ali. Monster Ali. My husband's name written. And next page 114. Let's stop, find Kapiluddin, my husband's name, 2 children, my 3 children's names are also written here. And 115 Lordship will find Siddhi Kushan is the enquiry. Same enquiry. Earlier, he stated, I am the daughter of Ikram Ali. Now stated Monster Ali. I always disputed before the tribunal also evidence of my statement also. So earlier inquiry dated lordship's report 70,001, subsequent 11/3/2001. Next page was similar case form 2 to inquiry similar 37. Then on issued notice, I submitted application lordship on received second notice, page 120. That I read lordship, the important lordship for adjudication of this matter lordship. That today, so and so is fixed for further evidence of the incident case. The name of the opposite party's father has erroneously been recorded as Monser Ali instead of Sonoti Giovanni.
This is not that's
Lordship.
the point.
But
You
here
please
is the
tell us, you see, from the documents you are showing, come
My-
to this
my
page
lord.
100 come to
Yeah.
page 113.
113.
113 refers to an inquiry which has been made in 11/3/2021,
Yes,
correct?
yes.
So here, even in this inquiry, you did not say that there was already an IMDT, there was already an inquiry and IMDT case was filed. That was on 10, that is in the year 2000.
No, in the petition stated lawsuit, in the page 121 lawsuit file, paragraph 8, that the opposite party previously also received a copy of notice from the Foreigners Tribunal 5th at Gwalpara, and according to opposite party appeared before the tribunal 8/2017 at so and so so and so, and the opposite party contest the said case, and thereafter the honorable member so and so so and so and so and so, and so in the district of Assam as a foreigner opposed 71 slip
Fine.
by
If that
WD
statement is there,
and the name of
it should be tied together. You can't proceed with on the premise that she's the daughter of A in one case and B in another case. The written statement is there.
Written statement,
She makes a statement with regard.
in which case, my lord, written statement could be.
earlier case.
121 is the 120 onwards is the written statement in FT 5954. And at that time, this. Oh, no, I was wrong. The page 120 is a written statement filed on 28/6/2019.
Yes, ma'am.
And in this case, in 2018, there is already a judgment.
Yes. There is already opinion, madam. In fact, the honorable court passed order prior to that, madam, in 18.
No, but still you see, it makes a statement before that court that I have not only suffered an opinion, but I have also filed a writ petition. Disclosing the name of the writ petitioner, the WBC 6052.
In FT case number 5/954 MA 19, madam.
Yes.
My lord, this is a separate case, my lord. Yes, this, my lord.
There
Robert-
can't be, you see, can there be two reference against?
No, my lord.
Yes and no.
No, my
Both
lord.
the cases should be taken up together.
No, this is already disposed of, my lord. The earlier writ petition,
We'll have to
the,
set aside.
yes, the,
We'll have
no.
to set aside this order.
the next proceeding may not be initiated, my lord. Next proceeding may
No,
be.
she's, in the other proceeding, you are giving her father's name as different.
Yes. So those are, my lord, that's why, my lord.
No, that can't be.
No, my lord, what my submission is, my lord. The next proceeding, whether the WS filed on 28/6/2019.
You see, whether right or wrong, she is taking the defense.
This taking the defense is the present case, my
No,
lord.
in this case also, she is taking the same defense, that my father's name is different.
Now at this stage, my
No,
lord.
Even in the trial, she has taken that decision, that. And therefore, you see, in the High Court also, the finding is to that effect. Look at paragraph 9 and 10 of the High Court judgment. The definite finding is that petitioner ought to have sought for a
Petitioner is
police
not the
report.
daughter
If
of-
consent opinion is proper. The same can be expressed in other way that the petitioner has failed to discharge a burden to show that she is not the daughter of Ikram Ali. Then again it says, para 10, later statement, she raises that the petitioner has been recorded as the daughter of late Ikram Ali instead of Aida, daughter of Sonauddin Diwani. So that is her constant stand. In this case and in the other case also, that she is the daughter of
Sonauddin.
Sonauddin Sheikh. There are two proceedings against the same person with different fathers. It will lead to injustice. Now, what happens? Mr. Payag,
My lord.
what happens now if she is held to be a foreigner as A's daughter of B? Then how do you take into custody? How you take her into custody?
The next proceeding is, my lord, initiated
2000 and 2001. First reference is in 2000, the other reference is in 2001. One
7
is
days
tried in
difference.
2018, the other is now being tried in 2019.
First reference 7/3/2001, second reference date 11/3/2021
Now,
inquiry.
just tell me that she is under detention camp. Now she is convicted here also of being a foreigner. How do you take her into custody?
That aspect, my lord, I cannot say whether she is the same person or not. That is,
No, let us
Yes.
assume that Mr. Prohibitions, what he's saying is correct. Now this woman is convicted again of being a foreigner. So please tell me, how do you take her into custody?
no, my lord, if the first one is already taken in custody, my lord, the second
Second
cannot,
one, how will you take?
the second cannot be taken. Same person, if it is same person,
Then
it cannot
it's
be.
injustice.
Yes. Yes,
In
yes.
first case, you are taking her in because she is the daughter of A. In second case, you are taking her into custody that she is daughter of B.
No. My lord, this is inquiry report. Definitely, my lord, it is the due, definitely if the father name is different. And
Your home can either make an inquiry at this stage that if two people are same, then both can be tried together. But if you say that there are two different persons, because you have the record, you will be able to say that which person has been against whom the inquiry was made. Even in the tribunals, now there is a requirement of keeping photographs of the proceedings. You can have certain whether the parties are same. Which the two
the
cases,
second proceeding cannot lie. ma'am. If parties are same,
but then you
the
have to
second
say
proceeding cannot lie.
father, who is the father?
That is their duty to establish, my lord, if he is the father or not.
No, you are accusing.
Yes.
You are accusing- In one case, you are accusing father is A. In another case, you are accusing father is B.
My lord, my submission is, what, this, my lord, if your lordship may kindly say page 113. Page 113, my lord. Only first line of the, my lord, the rule 4, then particular in relation to which information may be ascertained under rule 4 by the inquiry officer. These are the, my lord, form collected, these are the information collected by inquiry officer from the, my lord, from the person concerned.
You understand, but look at 115.
Yes,
This information was collected on 11/3/2001.
yes, my lord, same thing, my lord, this is right.
No, here she says on that day, when there was no proceeding against her
Yes.
in foreign tribunal, she says her father is,
No, that's why, my lord, same person, my lord, it is my submission. What my submission is that if I go for an inquiry, if she declares that my father is so and so in one case, and in another case, if she say my father is so and so, then what can the inquiry officer do? My lord, inquiry officer has to record what she states, my lord. That is the problem, my lord.
no. He is taking a defense.
No, she is taking a defense now, my lord.
No.
In the, no, they are in the writ petition, my lord, in the trial itself.
Yes.
That's, I understood. But, my lord, while do inquiry, there are some issues, my lord, if your lordship
remembers, my lord, in one case, I'm leaving apart this writ petition, my lord, in another writ petition. No, I'm just,
If you see, Mr. Pang.
no, I'm just disclosing a one fact, my
In
lord.
the year 2000, this inquiry
Yes,
at page 65 is of year 2000.
yes,
Correct?
it's 65, my lord.
Yes. And the proceeding starts in 2017. She immediately comes to the court on the first occasion of filing a written statement. She gives the defense that her father is not A but B.
Yes.
You see, on receipt or notice, petitioner Rahila Khatun appeared to the tribunal giving evidence of so and so. Now, para 3, what is the issue? Para 4, I've gone through the written statement. As well as documents in a written statement, obviously said you were born, brought up at Singamari car, whoever the son of the Sheikh and some of our parents. So that is our first defense.
Yes. So not been sick and something they were.
And in this case also, you take the same defense.
I understood, my lord. I'm not saying, my lord, they are not taking defense. My lord, the statement in this case was recorded probably in 2000, because this is a 2000, my lord. My learned senior friend is
Yes,
saying it was
no,
just
that is
7 days.
2001.
2001.
The second case is 2001.
In the present case,
And
my lord,
other-
it is probably 2000. Earlier was, next one is 2001.
Yes.
Next one is 2000. It is
Both
2000.
2001.
Now you see, come to page 60. In 68, everywhere, exhibit A, B, C, everywhere, some of them. Now, last part of this page, 68, but her name is recorded in the voters list, Rahila Khatun, and his name is Rahila Khatun. The opposite party states their parents, Sonuddin Sheikh and Samuel Sheikh, they are enrolled in electoral so and so. Now, after page 69, the fourth line, but on perusal of the case record, it is seen that the name of the father of the opposite is Ikram Ali. I have seen Ikram, therefore, Ikram Ali instead of Suman Diwani. And therefore, proceeds with the fact that the opposite party failed to establish and link with Ikram Ali. That means in this, if this opinion is accepted, then the fact finding by the ERO, inquiry officer, that is sacrosanct. So in second case also, the same principle will apply. If that is sacrosanct, then she is the daughter of Sonuddin Sheikh.
And second case, tribunal directed the police to make an inquiry. After inquiry found that I am the daughter of son of the lawsuit. That's order is also reflected.
You see, Mr. Pang, why the order of the court is wrong? Please come to page 77. You have read the opinion?
Yes.
Mr. Pang,
Yes, sir.
you have read the opinion. Now please come to page 77. Now paragraph 9 and 10. I am reading that.
Yes.
The plea of Mr. Saikia that the petitioner is not the daughter of late Ikram Ali, and the reason cited by the tribunal is disbelieving the said fact that the petitioner ought to have sought for the police report in a considered opinion is proper. Therefore, number one, this court feels that in the trial court, you should have called for a police report.
Yes.
Correct. Now, the same can be expressed in other way that petitioner has discharged her burden to show that she is not the daughter of Ikram Ali. But the tribunal does not proceed in the on the basis that she is not the daughter of Ikram Ali. She says there is nothing to believe. We have read that. Now come to para 10. In the written statement, the petitioner raised the name of the petitioner as recorded Rahila Khatun, daughter of Ikram Ali, instead of Aila, daughter of Sanoddin Diwani, in the proceeding. Under such circumstances, keeping in view the mandate of section 9, we are of the considered opinion that the petitioner failed to establish that she is not Rahila Khatun, daughter of late Ikram Ali, and instead she is the daughter of Rahila Khatun, Sanoddin Diwani. This was never the issue before the tribunal. Tribunal disbelieved that story immediately. So where is the question of proving it? The tribunal does not accept that proof. You can at best do is that will allow you to make an inquiry. You can make a discrete inquiry, give us a report as to what do you find. If you want, you can give it in a seal cover. It is your choice. But if you rely on it, it has to be opened and then disclosed. But there must be some inquiry. Where is the previous inquiry report?
Previous inquiry report is lordship will file one, page 40, lordship,
40.
page 40.
Where is this document, NRC? 1966 NRC, where is the
Yes.
document?
The NRC page 19, 20.
So you see in page 43, he discloses the name of the father and the IO writes his father's name so and so found in NRC of 1966. No, name of the person is Ruila.
Kapiluddin, page 43.
Kapiluddin husband.
This is father. I see. I see.
Let me kindly see there is opinion in the next case also, madam. Yes, in, page 123, madam, 123. She has been released from this case, madam. Page 23, madam, 123. Expressing doubt about the nationality of opposite party, regular person, daughter of Mansur Ali, wife of Kapiluddin, so and so, so and so. So here it is daughter of Mansur Ali. Now, my lord, in para 3, after receiving the reference to tribunal, please to issue notice to the proceeding appeared before the tribunal to submit WS and so and so, so and so. Wherein the opposite party, Rohila Khatun, daughter of so and so, so and so, Asmat Ali, wife of so and so, appeared in citizen. Now that according to notice was issued and so and so to the proceedings server went to the place of precedence mentioned in the reference cases per process server's report. He went to the place where the proceeding last recited and made an interrogation about the proceeding. And he met with the proceeding and handed over the notice to her. On the next day, the petitioner so and so appeared and filed a petition. My lord, we can just see. Yes. My lord, on the next day, so and so appeared and filed a petition stating that opposite party's father name is recorded in the cases Mansur Ali instead of Sonodi Devani and Sonuddin Sheikh. Hence, the petitioner prays for police report to the effect. Police report is received. Where police reported that the name of father of the opposite party is Sonodi Devani Sheikh and not Mansur Ali. And it is clear from the police report that the father name of the opposite party is Sundi Sheikh, not Mansur Ali. Therefore, the present opposite party who appeared in the case is hereby released from the case, and the tribunal directed to issue notice to against Rohila Khatun, daughter of late Mansur Ali, wife of Kafiluddin of so and so of the foreigners order. The process server reported that unable to find out the Rohila Khatun so and so an address mentioned above, pending which process server served the notice and so and so. No, my lord. Then, yes. Paragraph 5, my lord, yes. In pursuance of, my lord, this is not as per the, my lord, the 3(5)(f), she has been declared to be foreigner. Mansur. No, my lord, the person who appeared there, she is not the daughter of Mansur Ali. So she is not, this may be a different person now. Yes. The person who appeared, she has been released, man. The person, she appeared before the tribunal, saying that I'm not the same person. No. Yes. And yes. Yes. No, I have seen, madam. 113 is page 40 and page 113. Yes. Ikram Ali. Yes. Balogun. Boardroom. Yes.
Yes, yes, please, column 6.
Yes. Yes. Regular settlement. Yes. Age is different. Wife of so and so, that is woman.
Daughter.
Daughter. Husband's name, yes, ma'am. His father, well, also. Mansur Ali and another is
Ikram
Malad
Ali.
Ikram Ali. Now, Sunuddin. That is why, my lord, why this, my lord, what my submission is, your lordship may kindly consider this aspect. What I have submitted, my lord, this is the inquiry made by the inquiry officer, and these informations are collected from the, my lord, petitioner. These informations are collected from the petitioner. What my submission is, if she gives a false name, that my father is friendship, in both the case, my lord, it is not Sunuddin. In both the case. Yes. No. No. During inquiry, my lord. No. What my submission is, my lord. She may be daughter of Sunuddin. I don't know. She may be the daughter of Sunuddin, my lord. But this Rahila. No, my lord, it cannot be. My lord, that's why, my lord, only one person may be there. Only one person may be there. There may be two person also, my lord. No, there may be two person also. My lord, we don't know. That is why, my lord. Yes, there may be two people also. There may be one person also, my lord. Yes. That is why, my lord. Is there, my lord, if I may submit one thing, a person can, during the time of inquiry, my lord, they may say something that my father is X, but she may not have any documents to show that she is the daughter of X. Now she may take benefit in later part. They initiated. Yeah, I understood, my lord. Defense is taken. That's why, my lord, defense is taken in 2017 when case initiated, case proceeded. The initial time of inquiry, she has said in one case. Not that can be, my lord, definitely if she can establish. Yes. That is true, my lord. No, what my submission is, my lord, if your lordship may kindly see, these are the cases where the father name is paramount and very important because she has to link herself to the project father. But if, my lord, yes. That is why, my lord, that is what my submission is also. My lord, she has come and she has tried to prove herself. She has. Yes. That has to be proved, my lord. That is what my submission was. My lord, no, my lord, what my submission is, in either of the case, suppose in one case that my lord inquiry officer may committed mistake. Inquiry officer committed mistake that she is the daughter of Ikram Ali. And in another case, she is shown to be daughter of Mansur Ali. Now she is coming, saying she is not the neither the daughter of Mansur Ali nor the daughter of Ikram Ali. Now she is. Yes, I understand. Yes, written statement she has said, my lord. And now she is saying she is daughter of some my lord, Promoted Sheikh. My lord, in one case, my lord, if your lordship make a mistake, in one case, these are the cases, my lord, well, we have to see very carefully, my lord, if, with regard to their parents and brothers and sisters. In one case, my lord, the person who was declared to be foreigner, he got interim order from the Honorable Court. And when the reference is sent to against his brother, he appeared again there saying that I am the same person. And in the entire trial process, my lord, he appeared, he participated, he contested, and when he has been declared to be foreigner, he then disclosed that I am not the person. So it is my brother, I am not the person. So these kind of cases are going on there in the truth. My lord, your lordship may kindly consider what is the linked project document of the petitioner and the my lord, the projected father son of. Page 53, my lord. Yes. No, I'm not saying, my lord, she may not be the same person. She may be the same person. In both the cases, she may be the same person. My lord. But while inquiring, during inquiry, she has disclosed her father name in different matter. False. Other parts, no, that is not the defense, my lord. No, my lord, That is your percentage of it. You cannot say. Both the cases may be taken together, it may be demanded at whatever. Yes, he has not required.
No, no, no. No, because I have been released from that case. Order reflects, Lordship.
He has been released from that case. So he is not with respect to five cases. So in that case, my lord, that this order may be set aside and this case will be decided, whatever there is. In that case, he has been released. In next case, he has been released now. He is not interested in this opportunity.
Nothing is.
That's fine. If we resume, if we accept, para 9 and 10, ignoring para 9 and 10. Ignoring para 9 and 10, if we say this observation is wrong, 9 and 10. Suppose if we ignore that, the Ikram Ali dispute between Ikram Ali and the projected father, other materials may be various. Your Lordship may kindly see the petitioner failed to prove herself even to the projected father, whom the petitioner is claiming to be.
That evidence was never accepted. It's not a question of proving.
No, madam,
The
your
tribunal
Lordship,
never
that
proceeded that she is trying to prove that is the daughter of Sonatin Sheikh.
your
You
Lordship
see,
may
in
kindly.
the second case, what has happened? She takes the same defense. You
Yes.
read the both written statement, they are almost same. And in the second case, the court allows the police verification, and now it comes that she is the daughter of Sonuddin Sheikh. So her stand is accepted that she is the daughter of Sonuddin Sheikh, and therefore Sonuddin Sheikh's daughter is exonerated. And now ex parte who has been declared, daughter of Mansur Ali is
Mansur
declared.
Ali.
But you see the defense and the police report. She is the wife of same Kafiruddin. Kafiruddin does not have a wife by the name of what you call Rohila Khatun, daughter of Mansur Ali. So who has been declared to be a foreigner, a person who is non-existent. Now you are saying that we should send both the cases to be tried together. The second opinion is not even under challenge.
Yes, that is not understood.
That is not under challenge.
So that may be ignored, second opinion.
No, but second opinion is relevant because that is the source of the defense. That in that case, police report came showing me daughter of Sonuddin.
Yes, no, that is why, my lord. In fact, if your Lordship may kindly peruse for the time being, para 73 onwards, my lord, of the judgment. Page 73, my lord. The petition para 3, my lord. So it is their submission about to establish a linkage from parents Sonuddin Sheikh, and whose name appeared in 1966, 70, 79, 89. And Gwalpara, and mere failure to establish this under Akram Ali. So I'm not on that, failed to establish to Akram Ali. Whether she could establish by the evidences, madam, laid before the tribunal, that she is the daughter of Sonuddin Sheikh only. And then she laid evidence, the school certificate, my lord. As Sonuddin, daughter of Sonuddin Sheikh, and that observation is there in page 74, my lord, for this one.
So in 74, you see the crux of the matter, paragraph 4, line about 8 or 9.
Yes.
The name of Vikram Ali, father of the petitioner, was stated by none other than petitioner before the investigating team. And now the petitioner cannot project herself to be the daughter of Sonodhi.
Yes.
So
No,
the
that is,
was rejected.
that is, I accept, my lord, they cannot, but if we ignore this part also, what my submission is, my lord.
That can't be done. We can't permit that. To read a judgment in pieces and bits, that's something we can't permit. A high court order cannot be read like that.
No, otherwise, my lord, your lordship may remand this matter. My submission is, if your lordship remand this
You see,
matter.
it's a simple case, Mr. Payang. I ask you by what authority you are making your submission. You say that I am the standing counsel.
Yes.
I ask you that do you have a certificate of the department? Right now, you're not carrying it, and therefore I disbelieve. We don't give you an opportunity of.
No, my lord, here the opportunity was given. In this case, opportunity
No.
was given.
She's always trying to prove that she is the daughter of Sonodhi.
Yes, my lord, even whether my submission is, whether she could prove by adducing evidence, she has adduced evidence, DW1.
Has the tribunal appreciated that? Show us that the tribunal has appreciated the evidence of her as Sonodhi. It was rejected, even High Court rejected that.
No, my lord, according to the impugned opinion, it's, my lord, your lordship may find this is 74 owner. According to the
No,
impugned.
don't go to the High Court order. This
Yes.
we can't approve. We find it absolutely incorrect. The approach itself is incorrect. You come to the opinion, that is at page 65. In 65, that evidence was never accepted anywhere. Come to page 68, I've shown you that earlier also, page 68. Exhibit A, C, D. Or B also, yeah, missed out.
Yes,
Everywhere it's Sonodhi.
Sonodin, I understand. Even in school certificate, it is shown as Sonodin, my lord. Exhibit I.
In the school certificate, there was a reason to discard it.
Yes.
Because the headmaster came and could not say against whom the certificate was issued. So that was discarded, not on the
That
ground of father,
Yes,
but that was because this headmaster could not prove that document. Otherwise, she's also her defense is Sonodhi. Nobody is ready to accept it.
that your lordship remanded, set aside this opinion, my lord, and remand this matter for fresh opinion on the basis of her submissions, my lord. Her evidence, what is available there, my lord. Evidence to committed. If she gets, from the evidence, it is established that she is the daughter of Sonodin, she will survive, my lord.
Mr. Payang, again, same thing. It will be a horse before the cart. You see, you take our what is falling from the bench, you take that and proceed in that manner. It is only when you bring a police report saying that the two proceedings in the case A and case B are same, then only the other opinion can be set aside and remanded back for a fresh decision in a single matter. They both can be taken up together and then it can be decided. Because otherwise.
In the second case, my lord,
The second case.
they are not challenging it.
No, they will not challenge, but you can bring that challenge by agreeing to, by offering to bring a police report of both the cases, which will permit.
There is a police report, probably in the second case, there is a police report, so it is
The
said.
police report could not have come there.
Yes.
In the second case, her lawyer perhaps was different, was good enough to call it.
Yes.
But you
Here,
can-
they did not
But in
call.
this writ petition, you can make a prayer which will allow to have a police inquiry done in both the cases. Who is the actual proceeding?
But here, my lord, in fact, tribunal has in the present proceeding,
So if the
tribunal,
same person is the proceeding here also, then both can be sent back. Otherwise, we can't interfere with the second opinion. Second opinion is also of her. Husband name is same, village is same.
village is same.
They
Father
cannot
name-
be a Mansoor Ali.
Other name is different. then your lordship may have to, in that case, my lord, in some cases, yes, in some cases, this honorable court recorded,
So lot of things we are not doing. You make a prayer, we allow it, allow it. If you don't make a prayer, we don't allow it. The prayer must come from you.
no. My lord, I have to get instruction in this case, my lord, in that effect. Otherwise, if your lordship directs, I have no problem in my lord.
No, so much observations will be reopening of the other case.
Yes, that is why, my lord.
That is not permissible for us.
Yes.
So
That
you
is why, my lord,
make a prayer.
with regard to second case, I have to take instruction. And otherwise, I cannot, me also, it is difficult.
No, we'll do something we are out of the way. We allow the review.
Yes.
And then the writ petition is reopened. And the writ petition, we take a decision. The review is open, and then therefore you have time in the meantime to take a opinion. But this would not be acceptable. This ground for review has been made out. Third, Mr. Active Barbunia, learned counsel for the petitioner and counsel for the respondent. Sector. By filing this review application, the review petition, the petitioner has assailed the order dated 9/11/2018, passed by the coordinate bench of this court in WPC 6052 of 2018. Next meeting. The present the said writ petition was filed to assail the opinion dated 24/7/2018, passed by the learned member from a foreigners tribunal fifth, Walpara, in FT case number F T oblique 5/65 MA 2017, page 65, King's Club. Passed by so-and-so in so-and-so, IMDT reference number so-and-so. By the said opinion, the learned foreigners tribunal had rejected the plea of the defense plea of the petitioner that she is the daughter of Sonuddin Sheikh, Sonoddin SK. And on the premises of the police inquiry, where the name of her father was projected as late Gram EKRAN Ali, the learned tribunal had held that the petitioner Rohila, RAHILA, Rahila Khatun, daughter of late Ikram Ali, EKRAM, Ikram Ali, wife of Kofiluddin, Kofiluddin, of village Barkanda, Barkanda, under T.S. Matia, in the district of Gauhati, is a foreigner, of post 1971 stream, having entered into Assam on or after 25/3/1971. Full stop. This court on appreciation of the readings and evidence which was available on record. By the order under review dated 9/11/2018, disbelieved the plea of the petitioner that she is the daughter of late Ikram Ali.
It is son of the
As well as the plea taken in the written statement that her name is recorded as Rahila Khatun, daughter of late Ikram Ali instead of Ahila, Ahila, Rahila, daughter of Sonauddin, Sonauddin, Sonauddin Devani, Dewani, in the proceedings. And on the ground that the petitioner had failed to establish that she is not Rahila Khatun, daughter of late Ikram Ali, and instead she is Ahila Khatun, daughter of Sonauddin Devani, no error apparent was found on the face of the opinion, and accordingly the writ was dismissed. Next. The petitioner was subjected to another proceedings before the Foreigners Tribunal number 5th, Kualpara, which was registered as case number
page 120.
and page 123. Case numbers so and so. IMDT reference number so and so. And in the said proceedings, the petitioner was referred to as Rohila Khatun, Rohila, Khatun, daughter of late Monser, MONSER, Monser Ali, wife of Kapil, KAFIL, next word would be UWDIL, and by an opinion dated 9/8/2019, the said learned tribunal took into account the police report which was called for, where the name of our father was revealed as Sunuddi, Sunuddi, say SK, and not Monser Ali. And accordingly, the petitioner was released from the case. And the learned tribunal directed issuance of notice against Rohila Khatun, a daughter of late Monser Ali, wife of Kapil KA FIR, Expert Uddin, of village Barkanda. And thereafter, by holding that the notice was served, the said proceeding, Rohila Khatun, daughter of late Monser Ali, wife of Kapil Uddin, of village Barkanda, was declared to be a foreigner. Post 1971 street. Next paragraph. The petitioner, relying on the same said opinion, dated 9/8/2019, passed in the page 123, passed in Swell School, now relies on the said police report, which vindicates her stand that Rohila Khatun is the daughter of Sunidhi Sheikh, Sunuddi, Sunidhi Sheikh, who now claims that there was an error in appreciating the opinion dated 24/7/2018, which was essayed in WBC 6052 of 2018, wherein this court did not find any error in the opinion passed by the learned tribunal by ignoring her defense that she is the daughter of Sonuddin Sheikh, SONODDIN, Sonuddin Sheikh, and proceeded to declare her as affirm not find any fault with the said impugned opinion, wherein by holding that the petitioner had failed to establish that he is not Rohila Khatun, daughter of late Ikram Ali. Next up. The learned standing first for the FT matters has submitted that in the inquiry conducted by the inquiry officer, the inquiry officer had recorded only the submissions and disclosures made by the petitioner. And in the present case, she had disclosed the name of her father as Ikram Ali. And therefore, the proceeding was drawn up against the petitioner by referring her to as the daughter of Ikram Ali. In the second case, she declared her name of her father as Great Monset Ali. And accordingly, the reference was made. It is submitted that it is a petitioner who had declared her father's name wrongly when in the police inquiry. And therefore, there was no infirmity in the proceedings. And accordingly, he is justified the opinion under challenge, as well as the order dated 9/11/2018, passed in WBC 6052/2018. Next part. Having finished the materials available on the part, it is noticed that in the written statement, the petitioner had taken a consistent stand of her being the daughter of late of daughter of Sunuti Sheikh, SONA-DDI. With spelling variation as Sunuti, SONO-DDI, Sheikh, SHEIKH. And Sonuddin, SONODDIN, Sonuddin Sheikh, SHEIKH. And not daughter of late Ikram, EKRAM, Ikram Ali. Therefore, exhibit A, B, C, D, E, I, where reference was made to the petitioner being daughter of Sonuddin, SONODDI, Sonuddin Devani, or Sonuddin, SONODDI, Sheikh SK, and Sonuddin, SONODDIN, Sonuddin Sheikh SK, were discarded. Now the document evidence was appreciated with the view that the petitioner would be the daughter of Sonuddin Sheikh, Sonuddin Sheikh, SONODDIN, Sonuddin Sheikh. No, comma. This court in paragraph 9 and 10 of the impugned order dated 9/11/2018 took a view which is recorded as, which is extracted below. Page 77, para 9 and 10. Okay. Next. having regard to the fact that the defense taken in by the petitioner in the proceedings of page 65, FT case number 17, and the defense taken in the written statement filed in the proceedings of page 123 are similar to the effect that the petitioner claims to be the daughter of only coupled with the fact that in the opinion dated 9/8/2019, passed in page 123, the same learned traveler had accepted a police report disclosing the name of the father of the petitioner as Sunuddi, SUNUDDI SK, and not Monsieur Ravi. The court is of the considered opinion that the petitioner has been able to make out a case for reappearing her stand. Although that she is not the daughter of the Ikram. So we weren't interpreted with the order dated 9/11/2018, passed in WBC 6052/2018. In view of the said subsequent development that the petitioner has been released from the proceedings of FT case number so and so, page 123, owing to the fact that she is the daughter of Sunuddi, SUNUDDI, Sunuddi Sheikh, SK. Sheikh is SK, huh? According to the order dated 9/11/2018, passed in WBC 6052/2018, and record. Next. The registration now restore the proceedings of WBC 6052/2018 to file. Thereafter, the matter will be listed again. We will hear the repetition now.
Yes.
Yes, Mr. Salia, next is your matter.
Amla,
This week was also earlier decided.
To the other members of the bar, we may not have time to take up any other matter because at 4 o'clock we'll have to take a single bench.
Is that all?
Yes.
Three, if possible on Thursday, madam. Maybe,
We'll just ask the court master to take a call. Item 3, Sava. You're not assuring, but you will see.
Because I have just prepared hard to overcome Payang, my lord. Prepared hard to overcome Mr. Payang. I might forget, my lord. That is the reason Thursday.
You see, with the old saying, hard work makes a man perfect. You continue doing hard work.
That's true. No, the few small things which may get over, my lord. That is the reason.
Hammer it hard. You buy a new hammer. You buy a brand new hammer.
But the nail is not
Think
perfect.
a lot and hammer it again.
The nail is not perfect, my lord.
Surface is also rough.
Yes.
In this case also, earlier, around 2020, the coordinator has disposed of the matter, my lord, holding that the petitioner has failed to show that his parent or grandparents were ever residents before 1970 in India. And also, they further stated that the reference against 2 to 7, because along with one, Naivali, there were 6 others. They said that the reference against them was not there, so their names cannot be, their opinion against them has been set aside. In this case, I find the review holding that the learned court below have failed to consider the land document in favor of the grandfather of the petitioner in 1993, which was recorded in 1993. Madam? One person. No, earlier there were 7 persons originally. No, reference was against his wife and sons and daughters, there was no reference. So learned court held that the opinion of the tribunal against them is wrong. So that was set aside. So we are concerned with the petitioner number 1 only in this case, Naivali.
Yes.
In the order of the court below, in the last paragraph, it was stated, on examination of the position of W1 as well as W2 and the exhibits referred to above, herein above, none of the evidence tendered thereof proves or establishes the existence of Sahar Ali. Review file was also given.
Yes.
Projected father of the petitioner on Indian soil prior to the death of 25/3/71. The only evidence by which the petitioner seeks to prove the existence of his projected father Sahar Ali in the Indian soil is by way of exhibit Neo, which is a Jamabandi in the name of Saharuddin. On examination of exhibit Neo on the record, it is noticed that the name of Saharuddin was entered in the Jamabandi on 31/1/1977, which is a post-month document. In the absence of any explanation as to how the name of Saharuddin was entered in the Jamabandi Exhibit Neo on demand and the position obtaining before 77, which regarding the land mentioned in the Jamamandi vis-a-vis Salahuddin in Exhibit Neo cannot come to the aid of the petitioner, number one, in discharging his burden under section 9 of the Foreigners Act. In view of that, it was rejected. Against that, I filed a review contending that the exhibit in my review, this is exhibit J, but in the record, I have marked it exhibit Neo. Neo. There, you also will find it is marked in the original records that the Mamandi of the village, it is in the name of Badam Sheikh, the grandfather of the petitioner, was entered. And the note of the SDC, you also will find that it is dated 4/8/1933.
Yes,
In the original petition, read, it was an extra J.
no, in this Gauhati, it is not by way of purchase. Can't even read what has been written. So, this is not Khulda Dikne, Dokole. Sorot.
In tribunal record, you also will find that. Full sheet is there.
Yes,
In it-
but this is not Khoida Dokala Hotre.
But
The word written is,
no, it is to prove that he was present before 1970. That I want to, because it is a noting of 4/8/33.
there's no continuity. You have not shown that the continuity. You see, then you have shown us page 59. No, 15 of the record.
Yes.
Still, yeah, you won't succeed even if you have proved the exhibit neo. The reason is come to a written statement. If the written statement those facts are not pleaded, not even referred to the your grandfather in the written statement, then you suddenly exhibit this document without any pleadings. And in the evidence, you say that you refer to a mutation of 1931.
I think that was 33 was 31, so that's 31.
You have, what do you call, is the copy of evidence of DW1 annexed here? No.
Yes,
Which page? Page 44.
44. 44.
So here my father's name is dated in the year 1931. That is your evidence at page 42. And same thing is there in this assemblage version. And therefore, the document proof is not of 31. And there is no pleading. The written statement is annexed here.
Living prior to 30.
You understand, but it doesn't match with the document. Your written statement, which is available on the record, does not have that pleading. Your written statement is at page 38. Don't introduce your grandfather or the land. And I don't think your father's name was entered there. Your grandfather's name was entered in 33. So
Yes.
the evidence is to the effect that your father's name was entered in 31.
Well, but evidence is also there. Not only written statement, evidence is there. Evidence in court.
Emerald, Roy.
One 24/2019.
That one is cited.
No, I'm there. I'm here.
Oh, yeah, online. My lord. This is the, my lord, review application we have filed. For modification of the order. My lord, by virtue of this order, the original, how is, my lord, this was disposed of in terms of mediation agreement. No, my lord, our only prayer is that, my lord, mediation agreement, because the suit was filed, my lord, in connection with certain property, describing schedule A, B, C, D, and E. As it appears from the mediation agreement, my lord, some property were not included. So far as, my lord, A and B are concerned, those two properties were included. Rest of the properties were not included. Therefore, my lord, whether at this stage, my lord, can I have any right to make a prayer for, my lord, arriving at a fresh mediation, so that the property may be, my lord, properly distributed among the legal heirs? Only to that extent, my lord. You should kindly see the, my lord, original record is also not before this honorable court, but I can pass it on the plain copy, my lord. The original plain copy. There are as many as
All
five.
these properties are there. একটু মেডিসিন রিপোর্ট থেকে মেডিসিন কম্প্রোমাইজ একটু হয়েছে 73
You can mute yourself. You can mute yourself. Your
May I continue, my lord?
yes, yes.
My lord, lordship, kindly see, my lord, whether copies before your lordship or not, I don't know. Title suit, my lord. Have the copy of the title suit. There are 5 schedules, my lord. Initially, my lord, injunction was granted by this court only in respect to A and B. Ultimately, my lord, mediation took place. The mediation copy is annexed to the, my lord, review application. And page 68 of the review application, my lord, annexure E is the mediation agreement. As it reveals, my lord, in my understanding, my lord, only A and B is referred. Rest of the property is not referred. And we are not also against, my lord, mediation. Mediation, my lord, is a joint pair, and my lord appreciated ultimate mediation took place. And in the mediation, my lord, some properties were not included. It was subsequently realized by the petitioner, and immediately thereafter, my lord, they took a decision to and it is up to my lord, the satisfaction of the court, my lord. I understand, my lord, there is a compromise decree, it is not questionable. But since there is some error apparent on the face of the record, so lordship may be pleased to issue a direction to go for fresh mediation so that each and every property may be included now. And in the meantime, respondent number 1 died. And his property, so as it appears from the agreement, that they are going to make a trust. So far as his property is concerned, we have nothing to say. Original, my lord, ancestor, Havendranath Tankakuti died, leaving behind 3 sons and 1 daughter, and widow. And property was distributed. And his son, Rajesh,
Shankapati was the eldest son, and he got 1/3 share according to their agreement. And 1/3 share ultimately devolved on the petitioner. Therefore, we are claiming only 1/3 share. And that 1/3 share in respect of all the property. And they filed the suit in respect of 1/3 share of their predecessor. And it includes in defined schedule. Now it appears from the mediation agreement, there is a reference to only A and B schedule property. And to that extent, I pray that some direction may be given, to prepare both the party and to go for fresh mediation and to arrive at an agreement so that each and every member may get their dues, which they are entitled. Otherwise, my prayer is absolutely limited. I'm not questioning the, the authority of the court and as well as the order passed by this court. And I also want negotiation. I made request to them to divide their property. Initially, they refused. Ultimately, I was compelled to file the suit. I sought for injunction. My lord was pleased to grant injunction. And during the pendency of FOW, as per the direction of the court, negotiation took place as desired by both the parties. And this is the only limited prayer.
Yes, Mr. Das.
Lordship may kindly note that decree has been drawn on 9/6/26.
On the basis of
9/6/26. And the mediation report has been in full compliance of the civil procedure mediation rules, Gauhati High Court rules 2007. And during the course of mediation, nothing has been brought to the notice of the mediator at any point of time. And even now I say, my lord, there is all the properties which is there, my lord, it has been taken into consideration by the mediation report. And once the mediation files a report, my lord, your lordship will kindly see that civil procedure mediation rules 2007, rule 11 and 25. Rule 11, I have given a copy.
all the parties of sides, before the witness, including the advocate.
Rule 11, procedure of mediation has been followed completely and no complaint has been filed by the present petitioner at any point of time before the mediator. And if your lordship looks into the mediation report at page 73 of the petition, your lordship will find all parties, including the advocates, have signed a mediation report. Rule 11 of the rules 2007 has been totally followed. Rule 11 and 25. Court to fix a date for recording settlement and passing orders. All these rules have been followed. And I have provided a judgment of the Odisha High Court. Your lordship will look into it. Kindly paragraph 17 and 16 and 17. Once the mediation files a report, there is no citation is, my lord, I have provided a copy, my lord. 24th October 2025, I have seen. Citation is, my lord, Odisha High Court. I provided a copy, my lord. Similar rules have been followed. Paragraph 16, Rule 25 is quoted. And paragraph 17 is the relevant part. Once the dispute has been settled and the report submitted before the court, there is no other option available for the court than to pass a decree. And accordingly, decree has been passed on 9/6/26 to pass a decree in accordance with the settlement, subject of course to the situation envisaged under sub-rule 3.
Please give the date again. Decree date.
My lord,
Decree drawn on.
decree drawn on 9/6/26. Your lordship has earlier, my lord, allowed the court to take into consideration for passing a decree, my lord. What to say to that order?
You can declare that will be-
There is an order. I think the order has been passed on 10/3/26. Your lordship has allowed, given liberty to the district judge to draw decree. Accordingly, decree has been drawn on 9/6/26.
On the basis of the invitation.
On the basis of the mediation report. And your lordship will kindly see the petitioner has taken so many grounds in the review petition, particularly, my lord. It says, my lord, from paragraph 10, your lordship will kindly see of the petition. Petitioner says both the mediator as well as their engaged advocates fail to discharge their duties, responsibilities. Paragraph 10 of the petition. Petitioner states that both the mediator as well as their engaged advocate fail to discharge their duties, responsibilities. All have signed the report. My lord, review, your lordship knows, my lord, very limited role to play. If there is some small mistakes apparent on the face of the record.
But Mr. Professor has raised a point. That
Yes.
There are schedules C, D, and E. What
My
happens?
lord, yes. Yes, my lord.
In the suit, there were three more properties, C, D, and Schedule C, Schedule D, and Schedule E. And the settlement is only with regard to B and A and B. What about other properties?
My lord, it has been taken into consideration by the mediator, and accordingly, the mediation report has been submitted. And I don't find any specific ground in the petition taking all allegations against the advocate and the mediators. I don't find, especially, my lord, from page 37, I don't find this point has been taken by the petitioner. Luis, point.
Property wise, hotel or that is hotel.
All property wise, my lord, the report is given, my lord. If your lordship wants a detail on this.
It is only A and B, but the plaintiff has Schedule C, Schedule D, and Schedule E. Not
C,
taken
D.
into- Schedule C is land measuring 3 biga 3 kata.
Yes.
Schedule D is land measuring 1 biga 1 kata.
Hmm.
And Schedule E is a cinema hall, Viswa Talkies.
Yes, these are all there, my lord, but I'll have to explain to your lordships on another date, my lord, if your lordship wants to hear on that only. Because so many grounds have been taken in the
No,
petition.
other grounds I am not pressing, my lord.
No, but now he's saying so, but in the main point is not there. All this in the report takes into consideration all the, but since your lordship, fallen from your lordship, I'll have to explain on a different date, my lord, in details. The lordship look into the ground at page 37. Where is this specifically, my lord? So many other grounds are there. The face of it is not maintainable. But now he is saying, so I'll look into it, my lord. Any other date. Maybe next week your lordship may keep it, my lord. It is there, Schedule C, D, E, all properties are there, man. Even cinema hall is also there. I remember that.
No, the agreement is there at page 68.
Yes. My lord, on this, my lord, your lordship will give me one date, man. Otherwise, my lord, I was preparing for only on the grounds which have been mentioned by the petitioner at page 37. This Schedule C, D, and E properties, I'll explain to your lordship. Nazira. Your lordship, one clarification as regards schedule C, D and E, whether it is there in the report.
That is what Mr. said.
My lord, yes, my lordship may record that, no other ground should be argued.
Yes, yes,
This I will explain that, yes.
Yes, yes.
Mr. A.K. Purkasal, on counsel for the petitioner, submit that he may
ये
be
ground to answer the lawyer.
made a
Huh?
oral plea that in the mediation agreement, the properties described in Schedule C, Schedule D and Schedule E have not been accounted for. And he submits that fresh mediation can be ordered for the remaining properties. To bring a quietus to the dispute between the parties over the members of the same family. So it is submitted that so far as all other grounds of review, is not missing the same and except the issue as to the remaining property mediation can be held again. Next, Mr. P.D. Das, under senior counsel, assisted by Ms. Ardeka, will be with you, Ardeka, so that counsel for the respondent is present. So he submits that he would have the instructions and make submissions on the next date. Next, accordingly, list the matter, give a date after vacation.
Yes.
Yes, yes, ma'am.
It's 7 July.
My lord,
27 July.
my lord. My lord, a copy of the plain, my lord.
Give it to you.
I will supply, my lord.
My lord, here,
No, no.
huh?
No.
Yes, Mr. Das.
No. Here even the suit was also dismissed on 17/2/22. I have provided a copy of the order. Suit filed by them. That has also been dismissed. 17/2/22.
Yes, I thought there can be a possibility of second mediation for the rest of the property.
Yes. I'm absolutely with your lordship. Hello, our name may be shown in the cause list. I was told that our name has not been shown for the respondent.
If, So in fact, we had looked into it. I don't think your instructing counsels, what do you call the workout for first file. I think
We file in IA, my lord, it is there. There is an IA for condonation of delay, which we,
Delay was condoned.
yes.
just let me find out. Yes. Yes, it is available. Okay. The registry shall take note that the learned instructing counsel of the respondent one in the matter has filed wakalatnama in connection with IS Civil 769 of 2020, disclosing the name of Mr. H.K. Sharma and Ms. P.V. Hussain as the learned instructing counsel. With Mr. V.D. Das, attorney senior counsel, dealing them. So, accordingly, the name of the aforementioned and that counsel be reflected in the cause list for the respondents by listing the matter next.
My lord, date may be given, my lord, so that
27.
27.
27th,
27.
27th, we have given a date.
My lord.
27th.
Oblige, Your Honor.
27 July, my lord.
Will not be able to take up now
My,
before vacation.
No, yes, sir.
my lord. I'm grateful, my lord. Obliged.
Deeply obliged, my lord.